The applicants, Waterloo and their associated companies, were aware of this case for some time, but were not being sued. They were not named as a party, and thought the matter was entirely one between State Bank, the DOE, NEAC, and as you say, Port Magical. However, it came to their attention at a fairly late juncture that if State Bank succeeded with the claim, the nature of the orders given would affect them as well. And therefore, because of that, they said, well, we have a sufficient interest. We stand to be affected by this. If State Bank succeeds, it would mean that after we get EIA approval, or if we get EIA approval, they could bring similar proceedings as they've brought against Port Magical and say that we're not entitled to proceed because either they have an exclusive right or they weren't consulted. So the nature of the things, the nature of the remedies they're asking the court for can cover anybody else who wants to develop a cruise port in the Belize district.
So what transpired in court today?
Well, essentially, it was just the hearing of that application. The applicants, as I said, Waterloo and the other two associated companies, asked the court for permission to be joined as interested parties. State Bank resisted the application. The three defendants did not, namely the government of Belize, the NEAC, and the DOE, said, we don't have an objection if you come in as an interested party. And Portico, or Port Magical as it's known, did not resist either. They offered no objection to Waterloo coming in. And basically arguments were heard, at the end of which the court agreed that we had made out a case, satisfied the court based on the rules. We had an interest and ought to be heard, and therefore timeframes were put in place for us to file various submissions, and the dates of February 8th, 9th, and 10th of 2022 were then reserved for the hearing of this matter.